Can our Prime Minister or the Chief Minister of States or any other minister be removed from their position even without being convicted to an offense? Right now, no. But this might turn into a reality in the near future as the 130th Constitutional Amendment Bill talks about the removal of these positions even without being convicted to an offense. Hello and welcome to Drishti IAS. My name is Saloni Nandkuliar, and in this video, let us understand what this bill is all about. So the Union government tabled 3 bills in the Lok Sabha. The 130th Constitutional Amendment Bill plus the Jammu and Kashmir State Reorganization Amendment Bill 2025 plus the Government of Union Territories Amendment Bill 2025. Now, all these bills, they talk about the disqualification of Prime Minister, Chief Minister or any other minister if they have been arrested or detained for a period of 30 consecutive days. So, no conviction needs to happen, no trial needs to happen. A simple arrest or detention for a period of 30 continuous days is going to mark the removal of these positions. And this needs to happen in relation to a serious criminal charge. So right now, these bills are under review by a joint parliamentary committee. But once they come back, once they are reviewed, they will require a majority of 2/3 in both the houses of the parliament in order to be passed and to become an act. So this is what the bill is all about. Let us look at the key highlights of the bill in order to understand what the contention is all about. So this bill, it targets the Prime Minister, the Chief Minister and ministers across the Union, the states and Union Territory, including Delhi and Puducherry. So it talks about amending certain articles in the Constitution. First is the Article 75, where it talks about adding Clause 5A, which is for the Prime Minister and the Council of Ministers. So if there's a minister who has been arrested or detained for a period of 30 consecutive days, then the Prime Minister can render an advice to the President, and the President, by his presidential order, can remove that person, can remove that minister from his or her position. And if no such advice has been rendered within 30 days, then automatically on the 31st day, that person will cease to hold his or her office. This will happen in the case of minister. And if the question is of the Prime Minister himself, then in this case, no advice needs to be rendered to the President. The Prime Minister will himself resign within 30 days, and if not, then automatically that person will cease to hold office from the 31st day. This will happen in the case of Union. Similarly, for states, we have Article 164, where we talk about adding Clause 4A for the State CM and Council of Ministers. So if there is a minister who has been arrested or detained for a period of 30 days, then the Chief Minister is going to render advice to the governor, and that governor is going to remove that person. And if no advice is rendered, then automatically on the 31st day, the person will cease to hold his or her office. And if the question is of CM himself, then again, no advice needs to be given. CM will resign, otherwise he will cease to hold his or her office from the 31st day. And lastly, Article 239 AA, which is for Delhi CM and Council of Ministers. So all these articles, they talk about amending the Constitution, and they talk about the removal of the Prime Minister and the Council of Ministers. And what kind of offences? So they have to be arrested or detained for offences where the punishment is an imprisonment of at least 5 years or more. A serious criminal offense where the imprisonment is of at least 5 years or more. And in that case, if they have been arrested or detained for 30 consecutive days, they will be disqualified. But it also allows for reappointment once they are released or acquitted. So this is the highlight of the bill. This is what the entire bill is all about. But let us see what was the reasoning of the government behind bill bringing about such a bill. So the government simply said that these elected representatives, they hold the trust of the people. So they need to be honest, they need to be accountable, they need to be transparent, and they need to run the government in accordance with the governance principles, good governance principle. And we saw a case in Delhi where the then Chief Minister of Delhi, he was running his government from jail. So he was in jail, but he did not resign and he was running his government from jail. So in order to avoid similar situations, the union government said that there was a need to introduce these bills so that if there is any arrest or detention for 30 consecutive days, we'll remove that person. And once the person has been released or acquitted, they can again subsequently be appointed to that position. But what is the existing legal framework? How is it different from the existing legal framework? Right now, we are governed by the RPA 1951, which talks about the disqualification of MPs and MLAs. But here, the issue is, or here the clause is, that there needs to be a conviction. So, if the person has been convicted, if the MP or MLA, they have been convicted for an offense of 2 years or more, in that case only they will be disqualified. And if it is a serious criminal charge like drug trafficking or corruption, then the duration does not matter. But otherwise, the duration needs to be, the conviction's duration need to be 2 years or more. So it talks about conviction. It does not only talk about arrest or detention. There has to be a proper trial and conviction needs to happen. Only after that, disqualification will happen. So right now, the RPA is under function. And what is the criticism of this bill? So the criticism here is simple. First, it talks about arrest and detention. Now, both are different. Detention can happen even without an actual offense taking place. So just by mere suspicion or allegation, some political propaganda can be used and person can just be arrested or detained for a period of 30 days. No trial has to happen, no conviction has to happen, and he will be removed from their position. So this is against the principle of what? Being innocent until proven guilty. This is what our judicial system currently works upon. A person is deemed to be innocent, believed to be innocent until he or she is proven guilty without reasonable doubt. So this is against the principle of our current judicial system, of our current justice system. So this talks against the separation of powers of the judiciary. Because who can convict, who can punish somebody? The judiciary can punish somebody. So it talks about the separation of powers. It is against the separation of powers of the legislative and the judiciary, because the judiciary can convict and any person can be punished only after he or she has been convicted. Right now, even before convictions, the person can also prove to be innocent. The person can also come out as clean and innocent. So even without conviction, even without a proper trial, we're assuming we are punishing that person because we are disqualifying that person. We're removing that person from his or her position. So this is what the criticism is all about, that it is against the separation of powers, it is against the principles of justice, it is against these things, and simply merely on political propaganda, if there's only a suspicion, if there's only an allegation, this can be used against the person. So this is what the criticism is all about. But what is the way forward here? The way forward can be that we revisit these things, we revisit the bill, and the Joint Parliamentary Committee, it comes up with some recommendations, with some better recommendations for people to think upon. And the existing legal framework can be strengthened. The existing RPA system can be strengthened so that better trust and accountability is built in these constitutional positions. So that was all for today's video. Let us see what happens. Let us see what kind of recommendations these Joint Parliamentary Committee they give us. And then we'll cover this topic again. So thank you for watching. Now let us practice a question for prelims. Which of the following statements are correct about the proposed Constitutional Amendment Bill 2025? 1. It mandates removal of the Prime Minister or Chief Minister held in custody for 30 consecutive days under offences punishable with a minimum of 5 years imprisonment. And second, it retains the possibility of reappointment if the person is acquitted or released. So what is the correct answer? 1 only, 2 only, both 1 and 2, or neither 1 and 2? Please provide your answers in the comment section and we will meet in the next video.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.